In 1987, a 32-year-old lawyer named Marcus Whitfield walked into a Dallas courtroom wearing a suit that cost more than most people's monthly rent, carrying a briefcase that contained a single piece of paper. That piece of paper would eventually make him $500 million. dollars. But what was written on it wasn't a contract, wasn't a settlement agreement, and wasn't anything that any law school in America had ever taught. It was something far more dangerous, something that would change the entire legal system, and something that almost destroyed him completely before making him unimaginably rich. Before we go any further, I need you to do three things right now. First, type your country in the comments below so I know where you're watching from. Second, hit that subscribe button because this story gets absolutely insane and you don't want to miss what happens next. And third, share this video with someone who loves a good mystery because trust me, they'll thank you later. Now back to Marcus and that piece of paper. Marcus Whitfield wasn't born rich. He grew up in a trailer park in rural Tennessee where his father worked double shifts at a meatpacking plant and his mother cleaned houses for wealthy families across town. Every morning, young Marcus would watch his mother iron other people's clothes while their own hung wrinkled on a plastic hanger behind their bedroom door. Every evening, his father would come home smelling like blood and exhaustion, collapse into a chair that had springs poking through the fabric, and stare at a television that only got 3 channels clearly. This was Marcus's childhood. This was the life he swore he would escape. And he did escape. Through scholarships and student loans and working night shifts at a gas station, Marcus clawed his way through college, then through law school, then through the brutal first years of legal practice where young attorneys are treated like disposable commodities. He worked at a mid-sized firm in Dallas where partners screamed at associates, where 70-hour weeks were considered lazy, and where the only reward for good work was more work. Marcus handled the cases nobody else wanted: slip and fall accidents, minor contract disputes, the legal equivalent of garbage duty. But Marcus had something that most lawyers didn't have. He had a photographic memory, not the Hollywood version where someone glances at a page and recites it word for word, but something close. Marcus could read through hundreds of pages of legal documents, case law, and court transcripts, and his brain would file away the patterns, the loopholes, the tiny inconsistencies that other lawyers missed. It was like he could see the invisible threads connecting different parts of the legal system that weren't supposed to be connected. One night in 1986, Marcus was working late in the law library, surrounded by towers of legal books that smelled like dust and old paper. He was researching an obscure property dispute for a senior partner who treated him like a human search engine. The case was boring. The client was difficult. The pay was terrible. Marcus was on his 4th cup of coffee and his 2nd pack of cigarettes when he stumbled across something that made him stop breathing. It was a footnote, a tiny, almost invisible footnote in a Supreme Court decision from 1923. The footnote referenced an even older case from 1887, which referenced a legal principle that had been established during the Reconstruction Era after the Civil War. The principle was incredibly specific, incredibly technical, and incredibly powerful. It had to do with how certain types of civil judgments could be enforced across state lines under particular circumstances involving interstate commerce and federal jurisdiction. Marcus read the footnote again. Then he read the original case. Then he spent the next 6 hours reading every related case he could find. By the time the sun came up, Marcus had discovered something that would change his life forever. He had found a loophole in the American legal system so profound, so unexpected, and so perfectly legal that it was like discovering a secret door in a building everyone thought they knew completely. The loophole worked like this. Under normal circumstances, if you win a lawsuit against someone in one state, and that person lives in a different state, enforcing the judgment becomes complicated. There are rules, procedures, barriers. The whole system is designed to protect people from having judgments from other states imposed on them unfairly. But Marcus had discovered that under a very specific set of circumstances involving corporate entities, interstate contracts, and federal commercial law, you could create a situation where a judgment from one court could be enforced in a completely different jurisdiction with almost no defense available to the other party. It was technical, it was complex, and it was absolutely, perfectly legal. But here's what made it genius. Marcus realized that this loophole didn't just apply to normal lawsuits, it could be applied to debt collection. And not just any debt collection, but the collection of old forgotten, supposedly uncollectible corporate debts that had been written off years ago. Companies go bankrupt. Corporations dissolve. Partnerships fall apart. And when they do, they often leave behind millions of dollars in unpaid debts that creditors have given up on because the cost of trying to collect is greater than the chance of success. Marcus saw something nobody else saw. He saw that these forgotten debts, these supposedly dead accounts, could be resurrected, not through normal collection methods, which were expensive and usually failed, but through his loophole. By purchasing these debts for pennies on the dollar, then using his court trick to enforce collection through a federal pathway that bypassed traditional state law defenses, Marcus could turn worthless paper into actual money. But there was a problem. Marcus was just an associate at a law firm. He had no money to buy debts. He had no credibility to convince anyone to invest in his scheme. And he had no way to test his theory without risking everything. So Marcus did what desperate people do. He made a bet that would either destroy him or make him rich beyond imagination. Marcus went to a man named Leonard Kovacs. Leonard was what people in Dallas called a character. He owned pawn shops, used car lots, a strip club, and rumor had it, several illegal gambling operations. Leonard had cash. Leonard had connections. And Leonard had absolutely no problem with legally questionable business ventures as long as they were, technically, legal. Marcus met Leonard at 2 in the morning at a diner that served the greasiest food in Dallas and asked the fewest questions. Marcus explained his loophole. He showed Leonard the cases, the precedents, the exact legal mechanism. Leonard, who had never finished high school but understood numbers better than most accountants, asked one question: "How much can we make?" Marcus had done the math. If they could acquire $10 million worth of old corporate debt for $100,000, which was a realistic price given how worthless these debts were considered, and if they could collect just 20% of that through Marcus's court trick, they would make $2 million, a 20-to-1 return. Leonard smiled. "I'm in." What happened next was a masterclass in legal engineering. Marcus and Leonard formed a company, a bland, forgettable company with a name that sounded like it could be anything: Apex Financial Recovery Solutions. Through Apex, they began purchasing old debt, not from individuals. That market was too crowded, too regulated, too risky. They bought corporate debt, failed business ventures, bankrupt partnerships, companies that had dissolved years ago, owing money to suppliers, landlords, creditors. The sellers were happy to get rid of this paper for any amount of money. To them, it was truly worthless. The debts were old. The companies were gone. The assets had been liquidated years ago. But Marcus knew something they didn't. Marcus knew that dissolved corporations often had successor entities. They knew that corporate officers had personal guarantees buried in old documents. They knew that parent companies had obligations they'd forgotten about. And most importantly, Marcus knew how to use his court trick to enforce these obligations in ways that the debtors would never see coming. The first case Marcus filed was against a real estate development company that had gone bankrupt in 1981. The company owed $400,000 to a material supplier. The debt had been written off. The company was dead. But Marcus had traced the ownership structure and found that 3 of the original partners had gone on to form a new, successful development company. Using his loophole, Marcus filed a claim in federal court under interstate commerce jurisdiction, arguing that the old debt was enforceable against the new company through a complex chain of corporate successor liability. The defendant's lawyers laughed at him. They filed motions to dismiss. They argued that Marcus's case was frivolous, that his legal theory was nonsense, that the whole thing should be thrown out. But Marcus had done his homework. He had found the cases. He had built the legal foundation. And when the judge read Marcus's brief, something unexpected happened. The judge didn't dismiss the case. The judge wanted to hear arguments. The hearing lasted 4 hours. Marcus stood alone against 3 senior partners from a prestigious law firm who were absolutely convinced they would win. But as Marcus presented his argument, citing case after case, precedent after precedent, slowly building his legal framework, the mood in the courtroom changed. The defense lawyers stopped smiling. The judge started taking notes. And by the end of the hearing, everyone in that room understood that Marcus Whitfield had discovered something real. 2 weeks later, the judge ruled in Marcus's favor. Not on everything, but on enough. The case could proceed. The debt could potentially be enforced. And suddenly, the defendants who had laughed at Marcus were terrified. Because if Marcus was right, if his legal theory held up, they could be on the hook for $400,000 plus interest plus legal fees for a debt they thought had disappeared years ago. They settled for $325,000. Marcus and Leonard had bought the debt for $8,000. Their first case had netted them a 40-to-1 return. But this was just the beginning, because word started to spread, not widely, not publicly, but in the quiet corners of the legal and financial world where people trade information like currency. People started talking about Marcus Whitfield and his court trick. Lawyers whispered about it. Debt buyers wanted to know more. And the people who owed these old debts started to panic. Marcus and Leonard scaled up. They hired more lawyers. They bought more debt. They filed more cases. And they won. Not every time, but enough. Marcus had refined his approach. He knew which debts were collectible and which weren't. He knew which judges would accept his legal theories and which wouldn't. He knew how to structure his cases to maximize pressure on defendants to settle rather than fight. Within 2 years, Apex Financial Recovery Solutions had collected $12 million on debts they'd purchased for $600,000. Marcus and Leonard were getting rich. But Marcus wanted more, because he had realized something terrifying and exhilarating. His court trick didn't just work on small debts. It could work on massive ones. In 1989, Marcus discovered the Motherlode, a steel manufacturing company that had gone bankrupt in 1982, had left behind $47 million in unpaid obligations to various creditors. The bankruptcy had been messy, angry, and incomplete. When the dust settled, millions of dollars in claims had simply fallen through the cracks. Nobody thought this money could ever be recovered. The company was gone. The assets were sold. The case was closed. But Marcus saw something nobody else saw. The original company had been owned by a conglomerate. That conglomerate had been restructured multiple times over the years. But through a chain of corporate transformations, mergers, and spin-offs, Marcus traced liability back to a currently operating, highly profitable manufacturing corporation. Using his loophole, Marcus filed a federal claim arguing that successor liability attached through a specific provision of interstate commerce law that had been on the books since 1924. This wasn't a small claim. This was nuclear. Marcus was going after a company with $2 billion in annual revenue, a company with an army of lawyers, a company that would fight him with everything they had. Leonard was nervous. This was bigger than anything they'd attempted, but Marcus was confident. He had spent 18 months researching this case. He had built unshakable legal foundation, and he knew he was right. The target company tried everything to destroy Marcus's case. They filed motions. They hired investigators to dig into Marcus's background. They pressured the original bankruptcy court to intervene. They contacted the Bar Association with ethics complaints. They did everything possible to make Marcus go away. But Marcus had been careful. His case was legally sound, his documentation was perfect, and his loophole was real. The case went to trial. It lasted 6 weeks. The courtroom was packed with lawyers, journalists, and industry observers who understood that this trial would set a precedent that would reshape corporate liability law. Marcus, still technically an attorney working out of a small office with Leonard's money backing him, stood against a legal team that probably cost more per hour than Marcus had earned in his entire first year of practice, and Marcus won. Not completely. The judge ruled that full successor liability didn't attach, but partial liability did. The judgment was for $18 million plus interest and fees. After legal expenses and Leonard's split, Marcus's personal take was $7 million from a single case. But something else happened during that trial, something that would prove even more valuable than the money. Other companies started reaching out to Marcus, not to hire him as a traditional lawyer, but to make deals, because Marcus's court trick had exposed a terrifying truth to corporate America. Millions, Maybe billions of dollars in supposedly dead debt could potentially be resurrected and enforced against successor companies, merged entities, and restructured corporations. Companies that thought they were safe suddenly realized they might be vulnerable, and they were willing to pay Marcus to make the threat go away. This is where Marcus's story enters its most controversial phase, because what Marcus did next wasn't quite extortion, it wasn't quite blackmail, but it definitely occupied a gray area that made a lot of people uncomfortable. Marcus would research companies. He would identify old debts connected to corporate predecessors, dissolve subsidiaries, or abandon partnerships. He would trace the liability chains. And then he would send a letter. The letter was always polite, always professional, always technically legal. It would explain that Marcus represented a client who had acquired certain debt obligations. It would outline the legal theory under which these obligations might be enforceable against the current company. And it would offer a settlement. Pay us 30% of the debt value, and we'll release all claims. Fight us, and we'll pursue the full amount plus interest and legal fees through federal court using our proven methodology. Most companies paid, because the cost of paying 30 cents on the dollar for a dead debt was less than the cost of fighting Marcus in court, even if they might win. And the risk of losing, of having a judgment entered that could be tens of millions of dollars, was simply too high. Marcus had created a legal version of a protection racket, except it was completely legal. The money started flowing. Not millions. Tens of millions. Marcus hired a team of researchers to identify vulnerable companies. He hired lawyers to draft the demand letters. He created a systematic process for extracting settlements from corporations that had thought their old liabilities were buried forever. Between 1990 and 1995, Marcus collected over $200 million in settlements and judgments. But success creates enemies, and Marcus had made powerful enemies. Corporate lawyers hated him because he exploited their clients. Judges started viewing him with suspicion because his cases, while legal, felt predatory. Other debt buyers resented him because he discovered a strategy they hadn't thought of first. And somewhere in the background, federal investigators had started asking questions about whether Marcus's operation crossed the line from aggressive legal strategy into criminal extortion. In 1996, the FBI opened an investigation into Apex Financial Recovery Solutions. They interviewed witnesses, they subpoenaed documents, they tried to find evidence that Marcus had threatened companies, misrepresented his legal position, or crossed any of the lines that separated legal hardball from illegal conduct. They investigated for 18 months, and they found nothing prosecutable because Marcus had been incredibly careful. Every letter was reviewed by multiple attorneys. Every claim was legally defensible. Every settlement was documented properly. The FBI closed their investigation without filing charges. But the scrutiny had rattled Marcus. He realized that he had pushed his court trick as far as it could go. The legal community now understood what he was doing. Judges were less receptive to his arguments. Companies were fighting back harder. And the easy money, the settlements that came quickly because companies were scared and confused, that era was ending. So Marcus did something that shocked everyone who knew him. He pivoted. Instead of continuing to extract money from corporations using his court trick, Marcus started selling the trick itself. He wrote a detailed legal manual explaining the entire methodology, the case law, the procedural steps, the jurisdictional arguments, everything. He called it Advanced Corporate Debt Recovery through Federal Interstate Commerce Jurisdiction. It was 300 pages of dense legal analysis. And he started selling it to other debt buyers and law firms for $50,000 per copy. He sold 67 copies. That's another $3 million. But more importantly, by openly sharing his methodology, Marcus neutralized the perception that he was running some kind of sketchy operation. He became a teacher, an expert, a legal innovator who had discovered a legitimate litigation strategy and was now sharing it with the profession. The negative attention faded. The grudging respect grew. Between 1997 and 2003, Marcus transitioned from active litigator to consultant. He advised law firms on complex debt recovery cases. He testified as an expert witness in corporate liability disputes. He gave lectures at legal conferences. He became respectable, and he continued to quietly collect royalties from his old cases. Because many of the settlements Marcus had negotiated included ongoing payment structures that would pay out over decades. By 2005, Marcus Whitfield's net worth exceeded $500 million. The kid from the trailer park in Tennessee, the associate who worked in the law library at midnight, had become one of the richest attorneys in America. And he had done it through something that, on the surface, seemed almost mundane. A footnote in an old Supreme Court case, a loophole in interstate commerce law, a court trick that nobody else had noticed. But here's what makes Marcus's story really fascinating. The loophole still exists. After Marcus exposed it, after dozens of other lawyers started using variations of his strategy, after hundreds of cases were filed using similar theories, the fundamental legal principle remains unchanged. Because changing it would require either an act of Congress or a Supreme Court decision overturning over a century of precedent, and neither has happened. So today, right now, there are lawyers using versions of Marcus Whitfield's court trick to collect on old debts. The strategy has evolved. The tactics have been refined, but the core principle remains the same. Under specific circumstances involving corporate successor liability in federal interstate commerce jurisdiction, debts that appear uncollectible can be resurrected and enforced in ways that most people never imagined possible. Marcus himself is now 71 years old. He lives in a mansion outside Austin, Texas. He collects vintage cars. He funds scholarships for law students from low-income backgrounds. And he occasionally gives interviews where he talks about his career with a mixture of pride and something else. Something that might be regret or might be awareness that what he did, while legal, existed in a moral gray area that makes some people uncomfortable. When asked about his court trick, Marcus always says the same thing. I didn't invent anything. I didn't create any new law. I just read the cases more carefully than anyone else. I saw connections that other lawyers missed, and I had the courage to test a theory that everyone else thought was impossible. But was it just about reading cases and seeing connections? Or was it about something else? Was it about a kid from a trailer park who was so hungry for success, so determined to escape poverty, that he was willing to go places other lawyers wouldn't go? Was it about finding not just a legal loophole, but a psychological loophole in how corporate America thinks about risk and liability? Because that's really what Marcus discovered. He didn't just find a court trick. He found a pressure point in the corporate nervous system, a place where the fear of potential liability outweighed the rational calculation of actual risk. He found a way to make billion-dollar companies pay millions of dollars, not because they legally had to, but because the uncertainty, the potential exposure, the possibility that Marcus might be right was too terrifying to ignore. That's genius, but it's also, in some ways, predatory. The companies Marcus targeted weren't doing anything wrong. They had gone through legal bankruptcy processes. They had reorganized legitimately. They were operating profitable businesses and employing thousands of people. And then Marcus would show up with a claim based on corporate structures from decades earlier, demanding millions of dollars, threatening federal litigation, and offering settlements that were expensive but cheaper than fighting. Was it legal? Yes. Was it ethical? That's a harder question. Marcus would argue that he was simply enforcing legitimate debts that companies had walked away from, that creditors who were owed money deserved to be paid, that corporate successors should bear some responsibility for the obligations of their predecessors. And there's truth to that argument. But critics would argue that Marcus was exploiting technical legal doctrines to extract money from companies in situations where the moral or practical justification for liability was questionable at best, that he was using the complexity of corporate law and the fear of litigation to run what amounted to a sophisticated shakedown operation. And there's truth to that argument, too. The reality is probably somewhere in the middle. Marcus Whitfield was brilliant. He was hardworking. He saw something nobody else saw, and he exploited it ruthlessly but legally to become extraordinarily wealthy. He operated in the space between what's technically legal and what feels entirely right. And in doing so, he exposed something important about the American legal system. The system is complicated, incredibly, absurdly, dangerously complicated. There are millions of pages of statutes, regulations, case law, and legal precedent. The complexity creates opportunities, loopholes, exploits. Not bugs in the system exactly, but features that work in unexpected ways when someone smart enough to understand them and bold enough to use them comes along. Marcus was that someone. And his story raises a question that goes beyond just him and his court trick. How many other loopholes exist? How many other legal strategies are hiding in footnotes and old cases and obscure doctrines, waiting for someone clever enough to find them and brave enough to use them? The answer is probably more than anyone wants to admit. The law is built in layers, like sedimentary rock. Each generation adds new laws on top of old laws, but rarely removes the old ones. The contradictions, the gaps, the unintended interactions between different areas of law create a landscape full of hidden opportunities for those who know where to look. Marcus found one, made $500 million, and then, in a final twist that's either deeply cynical or deeply generous, depending on how you view it, he shared his discovery with the world. He could have kept it secret, could have continued exploiting it exclusively, could have guarded his court trick like a precious resource. Instead, he wrote it down, published it, sold it, and in doing so, he turned a private exploit into a public legal strategy. He democratized his loophole, which either ruined it by making it too common and too easily countered, or improved the legal system by forcing it to adapt and evolve. Today, Marcus Whitfield's legacy is complicated. To some, he's a legal innovator who discovered a legitimate litigation strategy and used it brilliantly. To others, he's an opportunist who exploited corporate complexity to extract money from companies in situations where the moral justification was thin. To Marcus himself, he's a guy who grew up poor, worked hard, got smart, found an opportunity, and took it. And maybe that's the real lesson of Marcus Whitfield's story. The American legal system, the American economic system, the American dream itself, they all contain opportunities for those willing to look hard enough and work hard enough to find them. Those opportunities might exist in gray areas. They might make some people uncomfortable. They might raise questions about fairness and ethics and whether something being legal makes it right. But they exist. And people like Marcus Whitfield will continue to find them, exploit them, and profit from them. Because that's what smart, ambitious, desperate for success people do. They find the loopholes, they discover the tricks, they see what others miss, and they bet everything on being right. Marcus bet on a footnote in a Supreme Court case from 1923, and he won $500 million. His court trick changed corporate debt recovery forever. His story became a legend in legal circles. And somewhere, right now, another young lawyer is working late in a law library, reading cases that nobody else reads, looking for the next footnote, the next loophole, the next court trick that will change everything. Because if Marcus Whitfield proved anything, it's that the biggest opportunities are often hidden in the smallest places. A footnote, a technicality, an obscure legal principle that everyone else overlooked. And all it takes is one person smart enough to see it, brave enough to test it, and hungry enough to pursue it to its logical, profitable conclusion. That's the story of Marcus Whitfield, the lawyer who secretly made $500 million using one court trick, the man who turned a footnote into a fortune, the legal genius who operated in the gray areas between law and justice and emerged unimaginably wealthy. But before you go, I need you to do three things one more time. First, type your country in the comments below, because I'm genuinely curious where all of you are watching from, and it helps the algorithm push this video to more people. Second, subscribe to this channel because I put out content like this regularly, and you don't want to miss the next story. And third, share this video with someone who would find it fascinating because stories like this deserve to be heard. Thanks for watching, and I'll see you in the next one.